Hey, so I am going through a ALJ denial decision. I've done this before where I point out things so people can understand what goes through an ALJ's mind and things that they might pull out and rely upon to make certain findings. So most of you, or many of you, may have seen some of the videos from me and some of my colleagues where we talk about the difficulties of proving a case or a person is unable to do all occupations out there, um, virtually all, of course, there are carve-outs, um, based on mental health limitations alone. And a lot of representatives and attorneys and non-attorney reps won't take a case unless there's some very severe mental illness, oftentimes of the nature that requires they have inpatient hospitalizations periodically. Um, that is not universal, but it is common, I would say. And I take a serious look at these things too, depending on the rest of the person's vocational profile. It is particularly arduous for those under 50. But even those over 50, it can be very difficult. So I'm looking at a denial, and I just wanted to point out the language that shows what this ALJ was pulling from. And it wasn't some abuse of discretion or anything like that. It's just that general garden variety depression therapy, anxiety therapy tends to get you garden variety type of medical records. So here's what the judge said, in essence. For the mental task required of many jobs, there's a requirement in understanding, remembering, and applying information. And if someone is unable to understand, remember, or apply information necessary to do simple job, that person would be disabled, because if they can't do it for a simple job, they can't do it for a more skilled job. So that would mean that there were no jobs the person had enough ability to understand, remember, and apply information to get the basics done. So the judge notes that in doing that, in the area of understanding, remembering, and applying information, this claimant had mild limitations. So she acknowledges there are limitations, as shown in the therapy records. She notes that the claimant alleges confusion, memory issues, difficulty following instructions, forgetfulness, etc. She points to various records in the medical evidence file. That's the section F file as you're heading towards hearing. And she also points to hearing testimony. She notes, though, however, the claimant's mental health treatment is routine in nature, without evidence of recommendation for a more intensive level of care, such as inpatient psychiatric hospitalization, partial hospitalization programming, or structure living. Now, I myself find it disturbing that one would have to point out, well, since there's no hospitalization needed, this can't be more than mild. I would strongly disagree. And I don't know that every ALJ would think along those lines. But it might be that she was only pointing that out because she goes further to say that the treatment records document generally normal mental status exams, other than variations in the claimant's mood. So apparently the mental status examination, which is those brief little observations a therapist might make and document, and should be, about demeanor, mood, affect, speech pattern, appearance, that would be hygiene, and putting yourself together when you go to the appointment. I mean, they do note the moods, but apparently, everything else is within normal limits. And a lot of times therapists do this. And is it because the person is totally presenting within normal limits? Or is it just that it's easier to check that box? I don't know. It depends how good your therapist is. So, and of course, the ALJ cites to the various exhibits in the F folder that purportedly support the fact that the mental status exams were largely normal, other than variations in mood. The ALJ points to the state agency opinion that showed moderate to mild limitations in that functional area we are talking about of understanding, remembering, and applying information. And she says, accordingly, the undersigned, that's how the judges refer to themselves when they present these decisions, the undersigned finds that the evidence of record does not support a higher degree than a mild limitation in this area. So that area was mild. In interacting with others, the judge in this instance noted that the claimant has moderate limitation. She points out that the claimant reports that she does get along well with others. She socializes with a friend who visits every week, has no problem with authority figures, although does generally not leave the house except for doctor appointments, and rarely gets together with other people, possibly largely due to significant stressors with other family members outside of her immediate family. The judge points out that the claimant is cooperative with and interacts appropriately with her medical providers. This is something that I see ALJs point out oftentimes when they're going to deny. The fact that we as patients behave kind of well-behaved when we're with our medical providers, it somehow shows that we're good to go. I don't really appreciate that, because everyone's on their best behavior except for the seriously, maybe dangerously mentally ill among us. And we can certainly be disabled without having that level of impairment where we have to be hospitalized and institutionalized. So it always bugs me when they say, acts totally fine with our providers. Well, A, we're there for a brief period, and B, of course we're going to be on our best behavior. And we hold it in or whatever we have to do if we feel we're tweaking, because we have to get through that appointment or they're not going to let us back in again, right? If we become a badly behaving patient, we might just lose our doctors. And if we are, we're also not going to get the treatment we need that day. They're going to send us home until we're feeling better. So I don't really appreciate that kind of draw from, that reality of what the records say, that, they don't show that you freaked out in the office, therefore you are A-okay. So again, the ALJ does note that the state agency had given the opinion of moderate to mild limitations in that interacting with others field that they have to look at. And the ALJ actually gives the claimant a higher limitation than the underlying SSA state agency had given by noting that she has moderate limitation in the area of functioning of interacting with others. Moderate is more severe than mild, but it is not marked and it's not extreme. And generally speaking, things that go from mild to moderate don't get found to be disabling. When there is, a couple of markeds or an extreme, then it can be disabling. So, they pick their choices depending sometimes, I think, on the result that they want. They want to deny, they're not going to go more than moderate. But moderate, again, is closer to marked. So this could be the type of situation where in a subsequent claim, if the person still has a window, if they're going for Title II, Social Security disability benefits, if they still have a window of insured status, if their DLI, date last insured, has not passed, their next records might actually push that over the top if it shows a little more anxiety in those mental status exams, which leads to the obvious add-on I'll give you, that don't be hiding anything when you're at your therapy appointments. You know, that's not to say don't be on your best behavior, but don't hide when you're anxious. Don't hide if you're tearful. Don't hide if you're frustrated. Don't hide if you're feeling hopeless and helpless. Don't hide that stuff. I know we all want to show that, yeah, we're doing good. We're good. You know, we can be very positive minded when we're their providers, but it's not going to help you. It's not going to help you. And here's a prime example throughout this decision. The next area is concentrating, persisting, or maintaining pace. The judge did find that the claimant had moderate limitation. Mind you, the end result of all of these in this case was that the claimant was in fact very limited mentally to unskilled work of a low stress nature and not complicated work. So that knocks out a ton of jobs, but that leaves all of those unskilled jobs. The remaining thing that would then kill off some of those jobs would be if the physical limitations were put her outside the scope of those remaining unskilled jobs. So it's multi-prong here, and that's typical. That's usually the way it is. The areas that the judge looked at in terms of finding a moderate limitation, notice it wasn't marked or extreme, was she knows that the claimant talks about her forgetfulness, lack of focus, difficulty following directions, can pay attention briefly, but then her mind wanders, et cetera, et cetera. But the judge found, relying again on the statement that the mental health treatment is routine in nature without evidence of recommendation for more intense level of care, such as hospitalization, partial hospitalization program. That's the kind where you go during the day and go home at night. It's usually a lot of group therapy, or structure living. So everything for this judge came back to the fact that there was none of that extreme level of care. Therefore, the symptoms aren't extreme. This kind of fails to take note that someone with children is probably not going to be willing to leave for an extended period of time to go to hospitalization. If they are getting by staying in the home structured environment, being cared for by family, no work, no stress, the family's doing a lot of the caring of the household. I mean, that itself is structured living, I'd like to argue. You know, sometimes when we have significant mental health struggles and our family is there to support us, we do get by without needing to go to a hospital because we have our structure. We have our wonderful care from family. And I think that needs to be pointed out that, but for that nice, calm, no stress, certainly not stress from work, even an unstressful job, as they say, has stresses. You all have to be, you know, acting in a certain way, behaving in a certain way, acting in a certain pace while we're on a job for 8 hours, and that's stressful. So yeah, I would argue that a highly structured home environment should count for something, but here it really didn't. And that is within an ALJ's discretion, I'm sure, to a large degree. So, and the state agency in that area of concentrating, persisting, and maintaining pace also found there was a moderate degree, not marked or extreme. And so the ALJ agreed in that situation with the state agency limitation. The last area, so there's always those four, the ability for adapting or managing oneself, she also found moderate. So notice how all these areas go all the way up to moderate, but none of them tip over into market extreme. That's by design, because if it did, there would be potentially a need to give an award. And if a judge does not want to give an award, they're going to make sure that these findings are following the law that disallows an award. So in this case, under adapting and managing oneself, let's see. The judge points to the fact that the claimant was compliant compliant with her mental health outpatient treatment. Therefore, she's adapting and managing herself quite fine. Wow. I just find that so cherry-picked and light. She notes that there is, again, no more than routine medication management and counseling for the mental health impairments. Again, the mental status exams are repeatedly reported normal other than variations in mood. She points out that the medical marijuana the claimant was prescribed and using was helping with chronic pain and helping her feel more relaxed and comfortable. And that she was coping with daily stressors. I don't know how, to me, that doesn't negate with being able to go and do an 8-hour-a-day job. I mean, this person isn't even doing a part-time job due to the fragility of the mental state. But let's see. And again, the judge points out what I noted before. The mental health treatment is without evidence of recommendation for more intensive level of care, such as inpatient psychiatric hospitalization, partial hospitalization, programming, or structure limit. Blah, blah, blah. So again, that whole adaptation goes up to moderate, does not go to marked or extreme. And the judge points out that pursuant to the law, because the claimant's mental impairments do not cause at least two marked limitations or one extreme limitation, this was going to fail. In terms of a listing, being so mentally incapacitated that you meet a listing. So, and then in the ending residual functional capacity part, which is noted in one of the bolded paragraphs you would see in any ALJ decision, the claimant was limited to, and this is severe limitations. It cuts out a lot of jobs, but it doesn't make for disabling because there are jobs that don't require this. This claimant is limited to simple routine tasks, but no complex tasks, low stress work environment, which she would be defined as occasional decision-making, not more than occasional. And occasional changes in work setting would be okay, but not more than occasional changes in work setting. But she can have frequent interaction with coworkers, supervisors, and the public. Frequent. Frequent, by the way, is a term of art, and it means up to 2/3 of the workday. If you're dealing with coworkers or the public that much, how can that even be a low stress work environment? I don't think it is. I don't think in reality is. But again, we're not dealing with our day-to-day reality perceptions here. We're dealing with what the laws say, and an ALJ's discretion. So, because this claimant was limited to unskilled work, low stress, she did not prevail because from the physical perspective, she was limited to light work, not able to do medium or heavy work. And if you are, there are plenty of light jobs that are of the unskilled, low stress nature that we're describing here. Being over 50 years old had the physical limitations, and this was a fibromyalgia case, had the physical limitations rendered her, according to the judge, to be sedentary, meaning more sit down, not able to do, in this case, it was like a sit stand. You can alternate every hour. For an hour, you could sit, an hour you can stand, and these jobs are still available. So it was light, except because it was beyond sedentary. Sedentary would be you got to be sitting all the time. You can't do more than that. You have to always be sitting in terms of your needs. So this one went higher than that because if the judge had found that the claimant could only do sedentary work and couldn't do more on her feet, like was found when you do alternating sitting, standing, then she would have been found disabled under the grids. So it was specifically, you could tell, just pushed for lights with that, even with that sit stand alternating accommodation of sorts. and which wasn't really an accommodation because these jobs allow for that. That's the nature. You can still do the work. So that's just an example, guys, of what they're, the ways they're going to pull out things. So it really behooves claimants to work with their, the representatives, whether it's an attorney or a non-attorney, to figure out what needs to really be emphasized. I don't know that you can get, you're not going to get, it's going to be very hard for garden variety, anxiety, PTSD, depression, even panic attacks, to get you beyond lower or less than able to do unskilled, to say you can't even do unskilled work. So that wouldn't be the battle. So even though I was pointing out, the things that why they wouldn't go there, and I thought some of the silly reasons why, as a practical matter, you're just generally not going to get there without some really severe, almost psychosis type of things, or big proof of agoraphobia, where the proof is undeniable that the person can never leave home. OCD, perhaps, of such a severity that it's so interruptive all day long. My eyes are tearing again. It's like I have that craziness going on. But so let's just say like the mental health part is going to be always very difficult to get past the unskilled. They're always going to say, unskilled. Not always, but by and large. So the focus would be, in this case, a person over 50 to get the judge to confirm only sedentary work. So if the person can't do their prior work, and with unskilled, they are not held to a higher standard of prior skilled work because of the mental incapacities, and they can only do sedentary work. Under the grids, they would be found disabled, even though physically they could do sedentary work. That's how the grids work for the over 50 crowd. Well, technically grids apply to under 50, but you're not going to be able to win under them because it all says not disabled for the most part. So the disorder of fibromyalgia, because it is not an objectively evident, it's a confirmable disorder, don't get me wrong, and it's recognized by the SSA, but I'm sure ALJs differ in how seriously they take it. The extent of pain and limitation is very subjectively shared because there's no diagnostics as to severity, only as to proving that it's a diagnosed condition. It makes it really hard. I personally think if you have fibromyalgia, obviously run with it, but not only with it, particularly if you're in your late 40s, early 50s or above. Usually we have degenerative problems. I would be pursuing orthopedics. If we have numbness and tingling anywhere, I'd be pursuing neurology. Do not leave it with a primary care treating you mildly for fibromyalgia and you're just living with the pain. Yeah, keeps watering. If there's numbness and tingling, I'd be getting diagnostics, so something to show that there is objective things going on, nerve damage, orthopedic problems, arthritis, degenerative changes in joints or discs in your spine. Getting this person to sedentary is going to be my job. And my recommendations for treatment that she's not doing, because it's all been, relegated to fibromyalgia, and therefore you just got to live with it. Medications are, the side effects are untenable for this person. So my recommendations are going to be, and hopefully the claimant will do them, get to orthopedics, get to neurology, get worked up for all these things, so that there is something other than fibromyalgia for the next ALJ to look at from a physical point of view. The mental, we've got it. That's not going to change as long as a person continues to treat as they're treating. I don't think that's going to be the issue. The issue is changing that light finding on physical to sedentary. And then she will have prevailed in her case. So that's going to be our goal. Okay. But I wanted to share with you what the ALJs point out when they're looking to deny. And if you have the opportunity to file again, like some people do, because they didn't wait till the last minute to file their, they didn't wait till the end of their DLI window to file, they will have another opportunity, and you can learn from your old ALJ denial exactly what you need to change. And that's the goal here. Use that little playbook they've just given you as to why you were denied and change those things. Some of them are changeable. The mental health thing, short of some extreme records coming out, that's not going to change. And that's fine because we don't need it to. We just need to get that light down to sedentary. All right. I'll talk to you guys later. Bye.